Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Okay. Now, there's something I want to put on the screen right now with respect to, and Professor Gyampo, I'll bring you here, this particular instance of the futuristic implication of the decision as Dr. Pagre Bwanche Dankwa made reference to. And we'll put it on the screen right now. And what the speaker said in his ruling. He said, if Article 97(1)(g) and H were to apply only to future parliaments, they would be rendered superfluous. By the time the next parliament is constituted, any member of parliament who has defected or switched political allegiance during the current parliament will no longer be in violation of this provision. They will start the next session aligned with their new party or as an independent. Thus, there will be no defection and the violation will be wiped clean. That is the speaker's ruling on this argument of the fact that these persons have expressed intentions to contest future elections. So why is a decision being taken now? For example.
No, you see, I think in the course of the week, I sent you some write-ups.
Yes.
About my positioning on this. I have always not shied away from swimming against the tide. I believe that Professor Michael Kwe was wrong in his ruling. Speaker Bagwin was also wrong in this particular ruling. And I have espoused my reasoning, for that. But I thought that we're going to look at the other matters that have risen as a result of such ruling. So, okay, if you would permit me, I'll go back to explaining why I think that both of them were wrong in their rulings that they gave. Then I'll also talk about the Supreme Court's response. Now, let's note this. See, there is always a historical antecedent to laws that are made. For instance, if today you are told that a president can hold office for only 2 terms of, 2 terms, you can do just 4 years and then you do another 4 years. Afterwards, you go away. If you want to appreciate why we have such a law, you must understand our history. In times of history or in our historical past, when independence fighters like Kwame Nkrumah, Leopold Sedar Senghor, Sekou Touré, and all of them had fought for independence and had attained independence, they said that, look, after all, our traditional political authorities, when they are appointed as chiefs or when they are selected as chiefs, they rule till they die. So if we have been able to attain independence for ourselves, we must also rule till we die. So they converted they formed one-party states and wanted to be presidents for life. The framers of the 1992 Constitution didn't want us to go there. That's why they said you can do a maximum of just 8 years. So that's a historical narration to that. Now let's come back to this law that has been a source of this confusion.
So on the basis of principle, it cannot be the case that you would agree with what's happening today. In fact, you disagree with what's happening today and agree with what happened in the case of Professor Michael Kwe.
No. I'm saying that both Okwe and Bagbin were wrong, and I want to explain why.
Yes.
Now, so the law that they quoted.
How about Wayoseni?
No, I'll come to Wayoseni's own. Wayoseni's own was the proper application of the law, and I'll come to that, please. So, in 1958, Kwame Nkrumah passed a law called the Preventive Detention Act. Now, that Preventive Detention Act mandated him, Nkrumah, to throw suspected political enemies to jail for 5 years. You go in for 5 years, and before you come, and your case will be heard. Sometimes you can go in for 5 years and then you come, your case is being heard and say you are not even guilty. But you may have served even for jail terms for 5 years. So through the application of the notorious Preventive Detention Act, several political enemies or political opponents in the parliament were thrown to jail. R.R. Aponsa was thrown into jail. Victor Owusu was thrown into jail. K. Busia had to flee. Now, there were some politicians or MPs from the Northern People's Party. You can talk about Dr. Bawumia's father, our current vice president and flag bearer of the NPP, his father. You can talk about Yakubu Tali. You can talk about J.A. Brima. Now, these and other members of parliament, out of fear of the intimidation tactics of Kwame Nkrumah, voluntarily had to go to Kwame Nkrumah and to plead that they want to cross carpet from their party to join the CPP. In fact, some of them, their constituents, went to beg them that for the sake of your own peace, cross carpet and join the CPP so that you can have your peace of mind. Now, around 1960, the number of the opposition in parliament had reduced from 32 to 16. And the number of the CPP members of parliament after the various cross-carpeting had increased to 88. Now, it was because they had this kind of majority. That was why they used the numbers to bring about the first Republican Constitution that gave all powers to Kwame Nkrumah. Now, when Nkrumah was overthrown, so I'm talking about a historical antecedent that brought into being these rules. When Nkrumah was overthrown, the framers of the subsequent constitution said that no, we cannot allow cross-carpetings like that to be going on so that we'll be weakening the opposition. So they introduced legislations against cross-carpeting in 1969 Constitution, in the 1979 Constitution, and in the 1992 Constitution. And the idea then was that if you belong to Party A, you cannot move from Party A to Party B when Parliament is in session. You see, they were trying to guard against what Nkrumah did by forcing the J.A. Brimas, the Bawumia's fathers, to move from the Northern People's Party to join their party whilst Parliament was in session. That was what the framers of this law sought to prevent. And so, if you now want to interpret it to mean that if you are a member of parliament, you cannot, the mere idea of declaring your intention to contest on another party's ticket would mean you should go away from parliament. I mean, it means you are not being fair to the spirit or the historical antecedent that led to the bringing into existence of this law. See, around the time that these four people were supposed to have declared intentions to contest on different parties' tickets, the number of parliamentarians, in parliament, according to both sides or according to the divisions, was the same. It was, after they had declared their intention, it was still 137, 1 independent. Nothing had been altered. 137, and 1 independent. The fact that somebody declared that tomorrow I will contest on MPP's ticket never altered MPP's number on the floor of parliament. So the law has to do with current happenings, current things that are happening in parliament. And my teacher, Prof. Michael Kwe, He knows this. He taught me introduction to Ghanaian politics. Okay, so he knows this. So I was worried that he gave that kind of ruling
in the Formina case.
In the Formina case. And now Speaker Bagbin also did the same. And that's why I'm arguing that both were wrong. And what is annoying is that when it was wrong yesterday, some people liked it. Today it is wrong and they are crying. And you are talking about the fact that the case of Formina is not the same as the case, that we have now. In the Formina incident, the man did not on his own say that he didn't want to be, he was actually dismissed by the party. He was actually dismissed by the party. And so it was not something that he said on his own that, look, I'm no longer NDC or MPP, I'm going to go to another party. He had only indicated an intention to do something in the future. Now, you're talking about the Wayo Seni's case. It's an excellent example of when the law was properly, implemented. In the Wayo Seni's case, he was a member of parliament representing NDC. And whilst parliament was still in session, during that same term, he said that even though I am an NDC member of parliament, I no longer want to belong to NDC. I want to move to MPP in that same parliament. And so he told the speaker alerted the EC, and he said, well, you've made your seat vacant. And that's how come his case was an excellent example of the application of this particular law. But the speaker's rulings, so far, in my view, looking at what really led to the bringing into being of these laws, of this law, the speaker's ruling, Michael Quay's ruling, Bagwin's ruling, in my view, were all wrong. And they were all, with Michael Quay's ruling, we heard what President Akufo-Addo said. He openly went about saying, I cannot work with this man. I cannot work with this man. This man was going for him as an independent candidate. I'll not go with him. I'll not work with him. And in my view, that constituted enough pressure on Michael Quay to do what he did. And in Abang Bagwin's case, to be fair, I'm sure he was also not going to be swimming against the tide. The NDC would have also taken him on. That if they did this the last time, you to do it. So they both were wrong. But in my view, Parliament, being a master of its own processes, must find its own ways to address some of these challenges. We cannot upset the balance of power that exists between the arms of government in a manner that makes Parliament subservient to the judicial arm of government and to the executive. The judicial arm of government absolutely has no powers to gag the functioning of Parliament. Parliament, in my view, and this is a simple, common, elementary O-level government. Those of us who studied the O-level and A-level government. Simple, elementary, basic O-level government.
Yes, sir.
Parliament is the only truly representative organ of government among the three arms of government. Why do I say so? How many people voted for Nana Akufo-Addo as president? He needed only 50% of the vote plus one.
Yes, sir.
Elsewhere, to make judges accountable to the people, judges are directly elected by the people elsewhere. So that you cannot be doing the bidding of any appointee, any high authority. So judges elsewhere are directly elected by the people. But when you if you come to in our part of the world, judges are not elected; they are appointed. It is only within the floor of Parliament that all Ghanaians have representation. So, in an attempt to locate where sovereignty resides, it is common O-level government to place it at the doorstep of Parliament. Because that is where all Ghanaians are.
Duly represented.
That is where all Ghanaians are duly represented. Now, there is a concept of judicial review that grants judges the powers to take a second look at the laws made by Parliament and to declare them whether they are constitutional or unconstitutional. It is there, judicial review. But if people can run to the Supreme Court and get them to halt the functioning of Parliament within the speed, in a speed of light, then there should be no Parliament at all. Then Parliament is useless. Because tomorrow we don't know who will be aggrieved. Parliament takes a decision and then he quickly goes to the Supreme Court and then he's able to get them. And the brazen manner with which Afenyo Markin was going about, I have taken it upon myself to, who are you?
He's the leader of the MPC.
And so what?
Majority leader.
And so what? So, like others have said, we have so many cases piled up at the Supreme Court. So many cases piled up at the Supreme Court. And recently, LGBT, anti-LGBT people, the pastors, the imams, the bishops, and all those
MPs.
The MPs, they all went to the Supreme Court to do something about this.
Yes.
They said they don't have time to do it. But one person is able to get you to sit in a day to take such a decision that, in my view, frustrates the functioning of Parliament. It is an unnecessary attempt to bring the legislative arm of government and the judiciary. But this cannot happen in any serious democracy. It must not be allowed to happen in any serious democracy. And you see, if you have Parliament led or presided over by strong-willed personalities like Alban Bagbin, then you will be sure that such personalities would fight back to assert the independence of Parliament. You know, they can also make laws to circumscribe the way and manner the judiciary also operates. It is within their right.
True.
Okay, so what has happened, in my view, has set the stage for a showdown, another political showdown. Now there's going to be a flexing of muscles between the legislature and the judiciary. And who is likely to suffer? So I'm asking myself, so if Speaker Bagbin comes to say, you said it, but we're not going to respect it, what would the courts do to him? Okay, so I think that the relationship must be guided by a certain mutual respect. Okay, of people must know their turf, and in terms of the balance of power, these are three organs of government that are supposed to wield the same power. But I'm saying that given the composition, how these organs of government are constituted, it is only within Parliament that all Ghanaians are represented. And so you cannot have the Supreme Court come in to frustrate the functioning of Parliament. And I'm worried because they were trying to ensure that government business wouldn't be stalled. And that's why they said they went to Supreme Court. But I can anticipate and predict that Speaker Bagbin would also want to put his foot down. He would also want to put his foot down to check what is going on. And the point must be made. Judicial review is not coterminous with judicial interference. They are two different things. Judicial review is not the same as judicial interference. Judges, the Supreme Court, the courts, the judiciary have the right to do what they are legally mandated to do. Parliament must also function. Okay? And so I'm hearing that people, the judges can also be cited for doing things that are contemptuous of the legislature, and it's also provided for in the Constitution. You are frustrating the work of Parliament, and so they can also cite you for contempt. So what happens if they also decide to do that? So I am thinking that, you see, the leadership of Parliament should be guided by a certain emotional intelligence and maturity. The leadership of Parliament should be guided by a certain emotional intelligence and maturity. And I'm thinking that if it had been someone like Osenchi Mensah, he would have known how to go about things such that we would have resolved this matter without plaguing ourselves with this anticipated constitutional crisis. I'm telling you, Tuesday, we are set for a showdown between the legislative arm of government and the judiciary. Because the man is also going to tell you that I also have my turf. Parliament's independence and autonomy must also be protected. We cannot allow a situation where Parliament cannot work because when they are deciding, they are not sure who would take the matter to the Supreme Court for the Supreme Court to say that what you are doing. I mean, we cannot anticipate, we cannot tolerate that. So, I am saying again, if they are leaders leading Parliament, let them begin to act proactively. Let them show maturity and begin to talk behind the scenes. If they don't do that, then the very things they were trying to avoid by going to the Supreme Court, they are going to see them in their worst form. Because, like I said, Bagbin would put his foot down. We know what he's capable of doing. I mean, the history of this Parliament, given the kinds of things that he's done, it points to you clearly that he may not countenance some of these things.
And that presents a very worrying and chaotic situation.
Why is it a chaotic situation? Yeah, because then there's going to be chaos, there's going to be lawlessness, there's going to be all manner of...
Because you cannot throw the speaker into jail. I mean, if he decides that...
Yeah, but the speaker is also going to tell you that what you did was also contemptuous, because you're also frustrating what he tried to do. So I think that we should have had a certain leadership that was going to be guided by some maturity. Okay? The brazen manner with which some of the things were said publicly, it created an impression that you know what is likely to happen at the Supreme Court. And any time, you see, if we want to build credible institutions, if our independent arbiters are to be trusted, it should be difficult for all of us to predict the outcome of their judgment when we are going there. But if you have a situation where somebody, I'm taking you here, I know what is likely to happen, and then they go and then the same thing happens, and it creates a certain impression that, you see, like has been said here, in the 2013 election petition, the value and the role and the importance of the Supreme Court was very much noticed by all Ghanaians. And the fact that they were the institution, it was an institution that held us together when we were all scared and we didn't know what is likely to happen. It was the Supreme Court that we looked up to. And so I don't belong to those group of citizens who would always want to lambast or run down the Supreme Court. I don't believe in that. But it is important that the Supreme Court itself strive to be in touch with reality. You don't sit in the comfort of the courtroom and then give rulings and judgments that are not, without taking cognizance of what is also out there in the public domain. It is not good. It is not good for our democracy. And so I am saying that if we have leadership in Parliament, let them begin to act now. Because I can anticipate that Speaker Bagbin is going to put his foot down on Tuesday. And so the stage is set for a certain unnecessary showdown that would now stall the course of government. And it is something that if we are truly serious and we truly want to govern and we truly want to prevent and allow government business, to be carried through, then we should begin to be acting, now.
PENDREAM TV now, so far so good. Say open online portal Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.